We'll moderate our language accordingly.
Can't do anything
guarantee that
with the dials. That's it. I'll let him know that you've.
I was going to tell him actually, but if you let him know, yeah.
Yeah. Thanks very much.
Not really supposed to take papers, but I'll stick it on their bench.
Yes.
Lord, briefly, on the question posed by my Lord just before lunch as to Mosaic, that there are two cases that your Lordships may find helpful. The first is in the bundle, the Tatry at tab 3. At page 535.
Yes.
This was a case involving an action for declaration of non-liability in respect of damage caused to a ship. And an action by cargo owners on the basis of shipping contracts in identical terms concerning the same cargo. So that was what court was looking at here. And one can see at paragraph 41 they look at the question of the object of the action. Means the end the action has in view. Question accordingly arises whether two actions have the same object when the first seeks a declaration that the plaintiff is not liable for damage as claimed by the defendants, whilst the second commenced subsequently by those defendants seeks on the contrary to have the plaintiff in the first action held liable for causing loss and ordered to pay damages. And the answer is they do have the same object. That's paragraph 43. As to liability, the second action has the same object as the first, since the issue of liability is central to both actions. The fact that plaintiff's pleadings are couched in negative terms in the first action, whereas in the second action they're couched in positive terms, as become plaintiff does not make the object different. As to damages, the pleas in the second action are natural consequence of those relating to the finding of liability, thus do not alter the principal object of the action. The fact that the party seeks a declaration is not liable for loss implies that he disputes any obligation to pay damages. So insofar as the claims concern damages, it would seem the fact that one is couched in negative terms and one is couched in positive.
Well, negative in the sense of I'm not liable for damages.
Correct.
Yes, which
it's the same object.
Yes. But those paragraphs would suggest that you're looking at you're looking at a number of aspects of the claims to determine whether they have the same object. Might suggest.
You are. Perhaps more helpful is another authority which I hope my lords had placed on your benches.
Just before we leave the Tatry, you say, do you, that it's clear that one's looking at both paragraph 43, whether the issue of liability, which is central, is the same in both, and then additionally, paragraph 44, you've got to address whether the remedies are.
You are looking at both.
So,
yeah.
44 focuses particularly on the remedies.
Exactly. And again, on this point, the authority which hopefully my lords have on your bench, based on Turkler, it's a decision of Mr. Justice Mance, as he then was. Paragraphs 8 and 9. This was an action in which there was a claim for damages on the one hand, and on the other hand, a claim for an injunction and declaratory relief. So, paragraph 8, the judge says it's necessary to bear in mind possible differences between the claims for declaratory and injunctive relief. Claims for injunctive relief do not, in my view, have the same object or cause as the action as the proceedings in Italy. The object means the end which the action has in view. Molino Boschi must show that Tofler's originating summons has the same end in view of Molino Boschi's action in Italy. It does not. In Italy, Molino Boschi are seeking to recover sums allegedly due on an examination of the terms and performance of the contract. Tofler in England are seeking to stop any such examination taking place in Italy at all. So effectively it's a non-suit injunction. And those two claims do not have the same object. One is for damages, the other is an injunction, anti-suit injunction. And then at 9, the rest of that paragraph concerns cause of action, so that's not on point. at 9, the judge says the claim for a declaration also has a different object and cause of action, in my view, from the Italian proceedings. Its object is less clear-cut insofar as it's trying to oblige or influence the Italian court to accede to Tocqueville's defence in Italy that the matter falls within a binding arbitration agreement. The object is to prevent the determination by the Italian court of the claims which it is Moylan Bosch's aim to pursue in Italy. So again, that declaration has a different object because it's seeking to prevent the court from carrying out the exercise. Insofar as it is to resist enforcement in third countries such as Germany or base a later claim for damages for breach of the arbitration proceedings, the object is again distinct from any at which Moylan Bosch's suit in Italy is aimed. So again, there's another example of a different object. There it's to, on the one hand, it's for damages, on the other it's to resist enforcement or base a later claim for damages for breach of the arbitration proceedings. So it's clear in our submission that one does have to look at the relief claim, the remedies claimed, when assessing whether or not something has the same object. The mere fact that there is a claim for negative declaratory relief doesn't itself provide a full answer to the question. Unless your lordships have any further questions.
No, thank you very much.
My lords, I'll deal with those points that my friend's just made in due course, if I may.
Of course.
Deal with his the first ground first, and then the question of including the question of the same object. Well, lords, we say essentially this appeal should be dismissed because the essential question in both the Norwegian proceedings and the English proceedings is the same. In other words, did Mr. Granath defame Dr. Wright and damage his reputation by publishing the tweet complained of? The essence of the claims is the same. And my Lord Justice Singh, if I can respectfully say so, has got the point right, that one has to look at the substance of what the cases are about. What one can't do is get into the domestic law analysis of particular causes of action because, of course, in some jurisdictions, certain elements will be, the burden of proof will be on the claimant. In others, the same elements will be on the defendant. Exactly how cases are pleaded depends on domestic rules of pleading. We don't know, there's no evidence, and it's not an appropriate investigation for the court to engage in exactly what you have to plead in a Norwegian action. We can't assume, and this is the heart of we say the error that Mr. Wolanski has fallen into. You can't assume that you've got to read a Norwegian pleading as if it was an English pleading, as if all the essential facts have to be set out and the causes of action have to be clearly delineated. If Mr. Wolanski's approach was right, it would mean that the application of Article 27 turned entirely on technical issues as to how one analysed particular pleadings in particular claims in different jurisdictions. And that's not what it's about. What it's about is avoiding irreconcilable judgments. In other words, the courts in one jurisdiction deciding one way and the courts in another jurisdiction deciding the other way, with the effect that the courts in the first jurisdiction will not permit the courts in the second, the judgment in the second jurisdiction to be enforced. I'll explain this in a bit more detail in a moment, but that's what this whole section of the Lugano Convention and the equivalent parts of what is now the recast Brussels regulation are all about. They're about avoiding the situation where one set of courts will not enforce the judgments of another because they don't fit with their own decisions. And if one just thinks about it, stands back for a moment, if both these actions proceed to trial, and if the Norwegian court decides that Mr. Granath is right, In other words, that, and I'll come on to looking at the opening writ in due course, but essentially he's saying Dr. Wright's claim is misconceived. He's wrong. This is not defamatory. If the Norwegian courts decide that, and the English, in this case, were to go to judgment in England, and the English courts were to decide it was defamatory and make a judgment in favour of Dr. Wright, it's obvious those two would be incompatible, and it's plain that the Norwegian courts in those situations wouldn't enforce the English judgment, because the English judgment would be the precise opposite of what they decided, and that's entirely what Article 27 is about, and it's not about. And Mr. Wolanski falls into error on this point as well. It is about risk, because of course it's possible that the two cases are tried in each jurisdiction. It's possible Mr. Granath loses in Norway, or it's possible Dr. Wright loses in England. So irreconcilability may never arise. But the question is not will it inevitably arise, but might it arise if the decisions go a particular way? And the position here is, we say, it's plain beyond argument that if you get to a position where Dr. Wright succeeds in England and Mr. Granath succeeds in Norway, you will have two irreconcilable judgments. We're talking here about a tweet which says, is about Dr. Wright's attempt to fraudulently prove that he's Satoshi. Mr. Granath says in his Norwegian proceedings that that's correct. The idea that somehow the Norwegian court could reach some kind of decision which would still be compatible with a case in England where it was found where as Mr. Wolanski had a hypothetical example, it turns out that Dr. Wright is honestly mistaken about his position in relation to Satoshi. It is fanciful. The position is in both jurisdictions, the allegation is in essence the same. And technical analysis to try and Mr. Wolanski seemed to be accepting that if certain additional words had been put into the Norwegian opening writ, he'd have no case. So if the Norwegians had just added the words, "we dispute the meaning," or something of, I think he conceded that at one point in answer to a question from the bench.
Well, I'm not sure he conceded that would fulfil Article 27. He may have been inclined to accept that might make the meaning a common issue.
Well, if the Norwegian, Mr. Wolanski's position must be that if the Norwegian opening writ had another paragraph in saying, and we want a declaration that that it doesn't bear the defamatory meaning contended for in the letter before claim, and that there's no serious harm to reputation, then he'd have to concede on his case. He'd then say, oh well, okay, fair enough, the two are mirror images of one of the other, because if he accepts, subject of course to his second point, he accepts that if you have a claim and a claim for the obverse, for a negative declaration, then that's within the scope of Article 27. So, my lords, we do say that this is an artificial exercise that Mr. Wolanski is engaged in, and he's bringing to it the wrong approach. Before I go into the detail about the judgment, can I just make Mr. Wolanski said very little about he took the court to the Alexandros T, but not really to any of the other authorities. And I just want to make 5 points, if I may, about about Article 27 and this section of the Lugano Convention. The first point is this: that the overarching purpose of the Lugano Convention and the equivalent EU instruments is to facilitate the recognition and enforcement of judgments between signatory states. One finds that in the preamble to the convention, and well, Lord, I won't take you to these judgments because these propositions I suspect will be uncontentious. But one finds that in the Eric Gasser case at paragraph 3. Lord Clark makes the same point in the Alexandros T at paragraph 23, and Lord Neuberger repoints it at paragraph 129. So we're talking about here, ultimately, about facilitation of the enforcement of judgments. My second point is this, that this part of the Lugano Convention and the similar parts of the recast Brussels regulation must be understood in the light of that overarching purpose. They have the common purpose of preventing parallel proceedings which lead to the risk of conflicting decisions, which would in turn lead to the judgment in one state not being recognised in the judgment of another state. Again, I don't think it's necessary to turn it up. The Tatry, this point is made in the Tatry at paragraph 32. Articles 27 and 28 pursue that common purpose, and that point's been repeated on numerous occasions. Just to give one example, in Easy Group at paragraph 47. So the difference between Articles 27 and 28 is not that they pursue different purposes, not that one pursues the objective of avoiding irreconcilable judgments and the other does not. The difference is that they provide two distinct but related tools to help to achieve that purpose. And Article 27 is a stricter rule. Lord Justice David Richards refers to it in Easy Group as being a mechanical rule. If it's right, it applies. And as I think the court has noted already, Article 28 provides a discretion. My third point is that Article 27 is a mandatory rule which requires the Second Seas Court to decline jurisdiction where the proceedings in the First Seas Court share the same cause of action and involve the same parties. And your lordships have already been referred on a number of occasions to the case law which makes it clear that same cause of action in the English and German versions should be read as meaning the same cause of action and the same object, which is what one finds in the French version. Cause of action means the facts and the rule of law relied on. And again, this is, I think, uncontroversial, and your lordships have been referred to cases which make this point. My Lord Justice Singh made it himself earlier. These are autonomous concepts deriving from the jurisprudence of the European Court of Justice. And it's important to emphasise that English notions such as cause of action estoppel have got nothing to do with this. How cause of action estoppel or issue estoppel works in English law is of no assistance whatever, because we're dealing here with purely EU concepts. So the question is, what are the basic facts and the juridical basis upon which arguments as to the facts will take place?
Can we just pause on that for a moment? Because you've said, and I understand, that these are EU law concepts and independent and autonomous concepts. But when one refers to the rule of law, so the facts and the rule of law which applies, what's the source of that rule of law? Surely that's not EU law. That's going to depend on the substantive rule of law which governs that sort of claim. And that will inherently derive from some national law.
No, because it's got to be done at a high level. So one can talk about contract. There's a concept of contract which in EU law which goes across. The law of contract is obviously slightly different in each European member state. There's tort and delict, and obviously the law of the law of negligence, the law of nuisance, the law of defamation is different. But at a high level, take nuisance, because nuisance, all these arguments that we're looking at also apply not just to personality rights, but also to cases of nuisance, which can can happen across borders and so on. The different jurisdictions have different concepts of nuisance, but you can't dig down into their fine detail. You've got to take on a high level and say this is a case about nuisance. This is a case about defamation, and that's the rule of law. The rule of law is protecting personality against false statements or something of that order. We can deal with it at that level, but we can't go down any deeper, because then it's not an autonomous concept anymore. We're talking about national law. And if one looks at the cases, and this is perhaps an important point, in none of the Court of Justice cases does the court consider evidence as to what the specific national law is on the issue in question. It always deals with it at this high level of abstraction. And I suppose...
Thomas, I'm sorry to interrupt you, but what happens if the substantive law of one contracting state doesn't in fact have any kind of legal label to be attached at all? At one time, some would argue even today, there was no wrong of breaching somebody's privacy in English law. So what do you do? In France, it's classified as a breach of privacy claim. What do you do?
That's exactly the point, with respect, that if you had a situation prior to 2003, when perhaps arguably, well, when a tort of misuse of private information emerged, prior to that date, though, there was no tort of misuse of private information, but there were particular forms of action which engaged what were privacy rights, as Lord Hoffman explains in the Wainwright case, your Lordship may remember. That Lord Hoffman says we don't have a general concept of privacy, but we have all kinds of specific ways of protecting it. Now, if a case had involved, before 2003, when there was a tort, if a case had involved issues about privacy in England, you certainly couldn't have put the label, this is a breach of privacy, because it didn't exist. But you could say, well, this engages privacy rights at a higher level, because, as indeed Lord Hoffman says in Wainwright. So you don't need the label in domestic law, but you need some more general, more higher level description of what's going on, and that's what the autonomous concept is. Now it's not straightforward to apply. I accept that, but there's no doubt at all that in the European case law, what they don't do is go into examining the contours of the relevant domestic law, because they don't need to, because that's not the issue. And just returning to my first point, if one thinks about the question of enforcement, if this is all about ensuring uniform enforcement, if you turn up in Slovenia with a judgment which appears to be in England for malicious falsehood. Now, do they have a concept of malicious falsehood in Slovenia? Well, I don't know. But if there's been a similar Slovenian action, the Slovenian court ultimately has got to decide whether that English judgment is properly enforceable. And the purpose of Article 27 is to stop a position where there are two conflicting judgments in the same area, the same general area. So if it's about false statements, I'm sorry.
I'm so sorry.
If it's about false statements made maliciously, malicious falsehood, and if there's some Slovenian cognate, then the Slovenian court, if there's a conflicting judgment, won't enforce it. And the purpose of Article 27 is to stop getting to that position.
But how can one decide whether judgments are irreconcilable or conflicting, leave aside for the moment whether there's a difference, unless you know what the ingredients are, i.e. that which you have to prove, in relation to each of the claims, and that must be governed by national law, mustn't it?
Well,
and if you can't tell what it was that you had to establish, how can you decide whether they're irreconcilable or conflicting?
Well, of course, you might devise a scheme, assuming as we have to that the domestic civil law is different in each member state. You could devise a scheme where everything was labelled under national law, under some uniform labelling system. So although the law wasn't the same, the labels were uniform, and so then you would know whether cases were concerned with issues which were the same and overlapping. But that's not how it's chosen to be done under the Lugano Convention and the Brussels the regulation, the recast Brussels regulations it now is. The choice has been to do it at a high level, for better or worse. But the choice of the European legislator and the treaty maker in the context of Lugano has been to do it at that high level.
I quite understand that the labels won't matter. If the claim in one country is labelled as defamation and in another country is labelled as breach of rights of privacy, that doesn't necessarily give you the answer. But I'm not sure that one moves straight from that to saying they're both about defamation as we would label it, if you don't drill down into what it is that you have to prove in each.
Well, the two things. First of all, we don't say it's about defamation as we would label it. We because we're talking about an autonomous concept. We're talking here about some defamation as an autonomous European concept. But I see your Lordship's point and your Lordship's concern. But I repeat my point. That's not how the European legislature has chosen to do it. That the European legislature has chosen to do it on the basis of this concept as a cause of action, as explicated by the Court of Justice, which does not operate by analysing the position in each jurisdiction.
Does the jurisprudence, looking at Article 27 of Brussels recast, the enforcement provisions, does the jurisprudence on that, on irreconcilable judgments, drill down into the ingredients of the national law in each case?
My Lord, I'm not in a position to answer that question. It's not something I've looked at. I apologise.
But given your submissions, if it does, that rather undermines your present point. But if it does support it.
Yes, but my Lord, what I can tell you, what I was just about to go on to, if I may, was the way that cause of action has been described in the cases, which is crucial. I mean, we all know, that cause of action in English law is a particular set of facts which gives rise to a particular claim, and historically these claims have been given different labels, actions on the case, different actions on the case, and defamation has had a particular label for several centuries. But the way that it's dealt with in the European jurisprudence is that, as I say, looking at it at a very high level, and if I just refer to 2 or 3 English cases where the point's been analysed, perhaps first of all in Primacon, which is at tab 7 of the authorities, and I would just say, I'm not going to deal with this point in any detail, but Primacon is a case which has been followed for many years. I mean, since it was decided in 2005, and the idea that somehow it's been implicitly, partially disapproved is fanciful. it's as we point out in our skeleton, that it was followed. Just to take one example, the very last case in the authorities bundle, it was followed by Mr. Justice Butcher in the Federal Republic of Nigeria case just very recently, and it certainly was not either explicitly or implicitly disapproved by the Supreme Court in the Alexandros T. But at paragraph 42 of his judgment, which is the one that was approved by the Supreme Court in the Alexandros T, Mr. Justice Cook deals with some of the questions that were being raised by my Lord Justice Popplwewell a few moments ago. Sorry, paragraph 39, first of all, the term cause of action in Article 27 is independent autonomous term, not to be confused with the use of the same term in the English jargon. And then he points out the point I made a few moments ago, that the French version is slightly different. It comprises the facts and rule of law relied on as the basis of the action. So that's what the European Court of Justice has said. And then at 42, he talks about the expression legal rule or rule of law, and he says this is the bottom of the page. The expression legal rule or rule of law appears to mean the juridical basis on which arguments as to the facts will take place, so that in investigating cause, the cause looks to the basic facts, whether in dispute or not, the basic claim, rights and obligations of the parties, to see if there's a coincidence between them in the actions of the different countries, making due allowance for the specific form proceedings may take in one national court with different classifications of rules and obligations from those in the different national court. And then he says, just a note in passing, that in relation to the objet, the search is for the end the action has in view or the essential issue raised between the parties.
Those are basic claimed rights and obligations. Claimed rights and obligations in accordance with local law. Okay.
Well, Lord, no, I don't think he means that, because he then goes on to say making due allowance for the taking one national court with different classifications of rights and obligations from a different national court.
But that doesn't seem to be saying claimed rights and obligations in accordance with some supranational EU law. It seems to be saying, as my Lord has observed, claimed must mean claimed under the law of the country that governs the claim, albeit, and this is perhaps where the tension arises, one then has to make due allowance for the specific form that proceedings may take in one national court with different classifications.
Well, my Lord, the point, on the facts of this case, the point may not matter, because here we are, obviously, we don't know the precise elements of the Norwegian law of defamation, but we do know that this is about defamation, because the authorised translation of the Norwegian opening writ, and we have the Norwegian court judgments, makes it clear that we're talking about libel, and the term libellous is used, and so on. So we're not dealing here with a complex and subtle issue that might arise where you've got an area of claim which is wholly unfamiliar to an English lawyer, and we're trying to match that up with something that's happening in England. We know that what this is about is defamation liable in both jurisdictions.
I understand that, Mr. Thomason, but I think at the heart, or certainly one of the central submissions that Mr. Wolanski has made this morning, is that you do have to analyse carefully. He submits, he may be wrong, but he says you have to analyse carefully what was actually alleged in the Norwegian writ. And he says, at its heart, what it was alleging was that the defendant, the claimant in that case, would be able to prove that the statement made in the tweet was correct. He says nowhere in that pleading was it ever alleged that something had been said dishonestly. And so he says dishonesty is not going to be an issue.
But the tweet says, the tweet refers to Mr. Dr. Wright's attempts to fraudulently prove that he's Satoshi. Well, it can't be you can't prove that that's correct without proving dishonesty in that respect. But can I just come back on another point your lordship makes, because there's an important and fundamental difference here between, on the one hand, when you're looking at what the rule of law, used in a sense that's not now familiar to us, but the legal rule that applies, and your lordship made the point about the need, and my Lord Justice Popplwewell made a similar point about whether you need to look at the domestic law. That's a different point from the domestic rules of pleading, because the fact that and this is, I say, an error that Mr. Wolanski falls into repeatedly. You can't analyse a Norwegian opening writ as if it's an English statement of claim, English particulars of claim. And the domestic rules of pleading, how you state the claim, are obviously logically completely different from the substantive rules of domestic law. Now, my submission is, and as I say, on the facts of this case, it may not matter, but my submission is that actually you're not supposed to dig down into the substantive domestic law as long as you know the general legal area in which you're operating. So as long as you know it's contract, you know it's nuisance, you know it's defamation, you know it's privacy, that's enough. That's it's not necessary, and I say this. Doubtless Mr. Wolanski will correct me if I'm wrong when he replies, but as far as I'm aware, there's no European case in which the Court of Justice engages in that exercise, because it doesn't regard it as a necessary part of the job under Article 27. Now, a completely different issue is how you go about deciding what's an issue, what the point is of the domestic proceedings. And that, again, is something that the European Court of Justice does not look at the rules of pleading and how things are expressed in different jurisdictions. Again, it takes what I would say a broad approach looking at the substance. And I'll come on to why I say the substance of what's an issue in Norway is the same as the substance of what's an issue in England in due course. But the point I'm making, as far as my third point so far, my third opening point is I'm talking about what a cause of action is according to the European case law, and it's put in very broad terms. It's the basic facts and the juridical basis on which the arguments are advanced, or the same basic complaint about the same basic facts. That's the formulation that Mr. Justice Butcher uses in the Nigerian Royal Dutch Shell case at paragraph 54.
But your submission, I'm sorry to slow you down even further, but your submission seems to essentially focus on the label. You say, is it defamation? Is it contract? Is it privacy rights? Is it nuisance? And that, you say, is an autonomous European concept. that label. But where are we to get those labels from?
It's the juridical basis. I would prefer that term that Mr. Justice Cook uses, if I can respectfully say so, to call it a label is slightly dismissive. You've got to put it into.
No, it's a character. It's a character. It doesn't really matter what you call it.
It's
a characterization.
It's got to be put into a category. You've got to put it into a category. You've got to know what the juridical basis is. Now, I quite see the form of the point coming from my lords that in order to do that, you've got to have some idea about substantive law. You can't do it, and there's a difficulty there which I accept, and in a difficult case it may cause real difficulties. But on the facts of this case, we don't have to worry about that because we know where we are. We know that this is in the territory labelled. It's in the land of personality rights and in the county of defamation. We know that. That's not in dispute. So we've got our juridical basis already. That's common ground. Now, the only issue, if you like, under this head is whether somehow we need to define that even more closely. We need to analyse that more closely in terms of the rules of domestic law in Norway and in England.
But suppose in one contracting state you can only succeed in a claim for defamation if you prove intention or negligence. Doesn't matter. It doesn't matter which of those you take, but there is some mental element. And in another jurisdiction, of which England and Wales seems to be an example, there's no such necessary ingredient. Does that mean that the juridical basis is the same? Or is it not?
Yes. My lord, it does mean the juridical basis is the same. However, you've also got to look at the basic facts. And to take my lord's example, if in Ruritania recently joined the EU, in Ruritania you have to prove intention to defame, then that will be part of the claim. So the basic fact of intention, and if there's a claim in England saying I'm not liable in defamation because the words aren't defamatory, then the basic facts are not the same.
But why can't then, in that situation, why couldn't someone say, I've been defamed in England, I may have been defamed in Mauritania as well, but I've been defamed in England, I don't have to prove intention to defame in English law, so I'll bring my claim in England. Why should it stop that person from bringing a valid claim in England because the law of Ruritania requires intention and somebody's brought some preemptive action there?
Well, but my lord, that wouldn't happen for the reason I just outlined. Because if the position was someone in Ruritania brought an action for negative declaratory relief, if they said in that action, I'm not liable because there's no intention to defame, but then there wouldn't be the same cause of action because the basic facts are different.
But that's fundamentally, as I think, what Mr. Walensky is saying, analytically, is what's gone on in this case.
Well, can I come on to the analysis of the opening writ? Because I don't agree. I will in due course.
Of course,
if
please come back to that.
But I'm sorry, I just want to have one more go on juridical basis. Suppose that the law of Ruritania doesn't have any law of defamation, but it does recognise as a tort or a delict the intentional causing of injury. And suppose that on the particular facts of a case, exactly the same factual issues would arise, including what you had to prove. In the Ruritanian claim for intentional causation of injury, and what would be categorised as defamation in another state where intention was part of the ingredient. Now, is the juridical basis the same when one is called defamation and then the other is just an aspect of delict law? Or at that stage,
if it was intentional,
do you say, no, they've got different juridical basis?
It's intentional, forgive me, if it was intentional damage to reputation, I mean, if you take it, malicious falsehood is not far away from that in English law. But because malicious falsehood, as your lordship, you have to prove malice, you have to prove a state of mind, has a mens rea, in contrast to defamation. If there was a foreign tort which wasn't labelled malicious falsehood or defamation, but it involved intentional damage to someone's reputation, then the juridical basis would be the same, because you're involved, the same kind of creature is involved, someone intentionally damaging someone else's reputation.
But in order to decide whether they're the same rule of law or rules of law, do you not have to look at the constituent elements of each rule of law?
Well, my lord,
because if the constituent elements are different, then you wouldn't have irreconcilable judgments.
Well, what you have to look at is you have to look at the juridical basis and then the basic facts, and if they're the same, then
yes, but that's what is the juridical basis.
Well,
is it not the elements?
Well, it's not. It's not the way that it's been analysed in the Court of Justice cases about, or in the English cases about the application of Article 27 and its cognates in the Brussels regulation. That's not how it's gone about. I can see that you, as I said before in answer to a question from my you can see that there might be a different way of doing this. But it would be much more complicated, because instead of this is as it were, intended to be a high-level rule to avoid the risk of irreconcilable judgments. You could have a much more finely grained rule for the same purpose, which would be involve a lot more complex investigation. That's not how the European legislators decided to do it. That's the choice of the European legislator, and obviously it gives rise to the kind of debates we're having now. But my lords, it's not the way it's been done in the cases. I quite understand, and I entirely accept that I have to show that the juridical basis and the basic facts are the same. I have to discharge that burden to show that Article 27 applies. But what I don't have to do is to start comparing the elements of the Norwegian tort of defamation, look at the Norwegian rules of pleading and compare them to how the English tort of defamation and the English rules of pleading work, and how those two integrate. It's simply not the way it's done. And it's important. This point is important, that the claims do not have to be identical. They simply have to. There has to be some shared essential element in question, which then gives rise to the possibility of the irreconcilable judgments. And if one looks at a case like Primacom, it's perhaps if the lordships may still have it open, but put very shortly, that was a case in which there was a loan agreement between an English bank and or a number of banks and a German company, and the German company had been in breach, according to the English company, of the agreements. And there also was a an exclusive jurisdiction clause for the English, for England, for English courts. The German company brought proceedings in Germany for a declaration that it wasn't liable to pay the interest, partly due to certain rules of German public policy, which have nothing to do with England at all. So the basis of the claim in Germany was a claim which couldn't have been brought in England, in the English courts at all. And yet, in relation to those, there were some ancillary proceedings to enforce part of the loan agreements, which Mr. Justice Cook held were not covered by Article 27. But in relation to the two actions, the one in Germany for a declaration that the loan agreement was not binding, and the action brought in England by the lender, Mr. Justice Cook held that Article 27 did take effect. And if your lordships look at the first holding, that was in circumstances where it's difficult to see how the German courts could find they were entitled to exercise jurisdiction in face of the exclusive jurisdiction clause. The German courts, however, the courts first seized, and the principles enunciated by the European Court of Justice meant the instant court had to stay the three sets of English proceedings if the same cause of action was determined. The declaratory proceedings, the object of those proceedings, the same as the Mainz proceedings, involve the same cause of action in relation to interest. So the requirements of legal certainty, comity and trust in judicial institutions require the declaratory proceedings to be stayed until 27, such time as the Mainz courts decide on its own jurisdiction. So the proceedings were not precise mirror images of each other. And as I say, the German proceedings involved certain rules of German public policy which had nothing to do with England. And yet, nevertheless, Mr. Justice Cook held that Article 27 applied, the equivalent of Article 27. And the most recent decision of this court in relation to again, the equivalent of Article 27 is the Easy Group case, which Mr. Wolanski referred to really in passing this morning. And in that case, there'd been a dispute over the use of certain trademarks. There were proceedings in Cyprus which arose out of what was said to be a settlement agreement. And there were proceedings in England for infringement of the trademarks. The judge at first instance said, well, look, the Cyprus proceedings are about contract, and the proceedings in England are about tort. And really they can't be the same cause of action. This court disagreed and held that because, although the relief being sought in Cyprus was completely different from the relief being sought in England, and it was about the construction of a contract, at the centre of both cases was the question of consent. Consent being an element of the trademark, lack of consent being an element of the trademark claim in England, and the claim in Cyprus being based on a contention that there had been consent. And in those circumstances, the equivalent of Article 27 applied, because consent was an essential element of both claims. And just standing back for for a moment, one can see, with respect to that court, precisely why that decision was made, because if the English court had held, if the proceedings had proceeded in parallel, and the English court had held there was consent, and the Cyprus court had held there wasn't consent, then plainly you would have two irreconcilable judgments. But it didn't matter, A, that the relief being sought was different, and B, it didn't matter that it may be that one court, or certainly the English court, might never decide on consent, because it may be that the trademarks weren't valid, so they could possibly have lost the action without consent ever being decided. And we say that, I mean, what those cases illustrate is there's no need for precise mirroring between the two actions. Of course, the paradigm case of Article 27 is where you have a contract, someone seeks to enforce it, and at the other side someone says it's not enforceable. Although in those cases the relief sought is different, first case it's damages and the second case it's a declaration, nevertheless it's fairly obvious that the two mirror each other. But that is not the only...
There was mirroring in that case, wasn't there? In the Easy Group case, because if one looks at the alternative reasoning, paragraph 51, the last sentence, if we're to judge the cause by reference to the claim in the Cypriot proceedings, as we're required to do, that claim was and remained in a form that potentially put in issue all the elements of the claimant's claim in the English proceedings.
But it was
and
not
the word potentially is there because, of course, the disputes have been narrowed by undertakings or...
The disputes have been narrowed, but also...
But the claim itself
but also
put in issue all the elements of the English claim.
Well, as your Lordship says, that's the as it were, an alternative ground of decision. I mean, what Justice David Richards says is earlier in the judgment is that because this is paragraph 40. That if the claims are examined with regard to possible defence, without regard to possible defences, it's apparent that the claimant's consent to the use of marks or lack of consent is an essential element in both claims. While the Cypriot proceedings are more extensively relief sought, there's not a complete overlap. The essential question is whether the cause is mirrored in the Cypriot proceedings. In my judgment, it is in my judgment as regards the issue of consent. And then it goes on to consider the effect of the undertaking. But my Lord, the point I'm relying on this case for is the general point that you don't have to have precise mirroring between, for Article 27 or its equivalents to apply, you don't have to have precise mirroring between the two claims, as long as an essential element is common to the two of them. That's sufficient.
You say and.
I'm sorry?
You say and essential element.
And
the
essential element.
Because the passage you just referred to refers to the.
Well, your Lord's quite right to pick me up on it.
I wonder whether your submission was an rather than the.
Well, if I would say an essential element, because if the position is that in one case it's essential to prove something, and in the other case it's essential to prove or disprove the same thing, you run into the risk of irreconcilable judgments, because the two courts could take opposite views.
So
it is an essential element.
So it is the.
Yes.
If there is more than one essential question in each, and there isn't overlap in respect of each of those essential questions, does the same principle apply?
Well, if the essential question in Action 1 was consent, and the essential question in Action 2 was the validity of a contract, obviously not. But Mr. Hutchin points out to me that Lord Justice David Richards uses "and" in his when he talks about he says paragraph 40, third line, an essential element of both claims. Again at 45. Well, also, just so to put this point to bed, I don't. It's not controversial. I've never intended to argue. I wouldn't say I never argued, but I certainly not intended to argue that the fact that something might be a defence is something that should be taken into consideration. I entirely accept as that the cases are absolutely clear. You look at the claims and not the defences. However, if you have, as is very often the case, you have in the second action you have matters, or in one or other of the actions you have matters being raised in the claim, which would in the first action be defences. You can take those into consideration because the court's looking at the substance, not the form, and it's not looking as to how particular systems divide, particular systems of domestic law divide between claim and defence. But what's important is what appears in the claim document in each case. And what you can't take into account, I entirely accept, is things that might be in the defence document at a later stage. Or indeed in amendments to the claim documents. I think Lord Justice Moore-Bick makes clear in the case my friend referred to this morning. The fourth point I was going to make, is just to draw the contrast, which I think the court has well in mind, between Article 27 and 28. Article 28 is a much wider, more flexible tool. And in that case, there doesn't have to be any essential element in common. It doesn't have to be the same facts and the same juridical basis. Any connection between the proceedings is potentially sufficient to bring Article 28 into force. So even if the issues which are inessential to the first claim, if they're going to be determined in the second claim, potentially Article 28 can be invoked to stay the second claim. Article 28 isn't to be interpreted restrictively, and well, I'm not going to take you to it, but in the Euro Echo case, Lord Savile's analysis in a case called Sario and KIA is cited by this court to the effect that it shouldn't be interpreted restrictively. And my lords, my fifth and last introductory point is this: that the overriding nature of Article 27 is recognised in the jurisprudence, and it is clear from a case which some of your lordships may recall. When it came out, it certainly caused, I won't say consternation, but surprise the English bar. A case called the Irreconcilable, which is the case about perhaps the most famous Italian torpedo case, where there'd been there was an exclusive jurisdiction agreement in favour of Austria, but the Italian counterparty brought proceedings for a negative declaration in Italy. And the argument was that this was purely a tactic to delay proceedings, and it shouldn't be allowed to take place. And because the provisions, Article 17 of the regulation, which provided for jurisdiction agreements, should effectively take precedence over Article 27. And the Court of Justice said no, that there must be a mandatory stay under Article 27, whatever the apparent motivation of the parties and whatever the apparent defects of the Italian judicial system. One of the arguments run by the United Kingdom in that case was that there ought to be an exception if you were going to have terrible delays in the Italian courts. Now your Lordships may know, but what happened in practice is that the latest version of the Brussels recast regulation has an exception in to deal with this problem, so deal with this issue. So now Eric Gasser would be decided the other way. But the importance, the point I'm making is that the court recognised that without such an exception written into the regulation, the convention, the Article 27 overrode everything else, and that the court...
And that remains the position under Lugano.
Indeed, it remains the position under Lugano, as your Lordship says, because the amendment wasn't made to the Lugano Convention. So, my Lords, those are the introductory points I want to make, and I now turn to my friend's submissions. Can I just deal very briefly with the point he makes? He made it rather late in his oral submissions. He makes it first in his written submissions. It's a point that I think can be disposed of quite quickly. That the judge wrongly applied the test of the risk of irreconcilable judgments. That's not wrong. The point is, there may never be irreconcilable judgments because two courts may take the same view. The question is always, is there a risk that if the two courts take opposed views on an essential element, is that going to mean that one of the judgments won't be enforceable? So the judge was quite right to refer to the risk of irreconcilable judgments. In the Easy Group case, Lord Justice David Richards, again, if your Lordships have it open, it's paragraph 44, he refers to the potential for irreconcilable judgments. And that's what Article 27 is concerned with, the potential problem. It doesn't have to be an actual problem.
If we take, say, a very simple case, hypothetical I know, but let's suppose that English law and Irish law, one contract, are exactly the same. It's exactly the same facts which are the subject of the action. You would say, of course it's possible,
yes,
that there will not be irreconcilable judgments, but it's the fact that when analysed, the two claims are the same claims.
Yes.
Therefore, there is a risk of irreconcilable judgment.
Yes, and I would say it also obviously goes further than that. If you had the Irish supplier sues for payment of monies, and the English obviously assuming the validity of the contract, and the English counterparty brings another action based on the same contract, but essentially raising the issue of whether the contract, both raise the issue of whether the contract is enforceable, then there's a risk of irreconcilable judgment. even though one is not the precise mirror image of the other.
And it's your submission that if there is a risk of irreconcilable judgments on one possible permutation of the findings in each court, that's sufficient.
Yes.
And so that when you talk about an essential element, you don't mean essential, or you say that the authorities don't mean essential in the sense of something which is at the heart of or the centre of the claim. It just means one ingredient that it's necessary to prove in both actions. Yes,
if it's one ingredient that's necessary to prove in both actions, if it's something that's collateral, then we're in Article 28 territory. So there was the disputed Euro-Echo was about pollution in Poland, and the allegation, the defamation case was based on a wider claim about polluting conduct, and the nuisance action in Poland was about whether benzene had been released into the atmosphere. So the two weren't identical. So and it was possible. It would have been possible for both to succeed without any conflict. But because the issues were very closely connected, it was a potential Article 28 case.
But can that be right? Suppose I own a chattel and somebody damages it, and then somebody else steals it. And the only thing that the claims have in common, they do have this as an essential ingredient in common, is that I have to establish that I was the owner of the chattel. And that's an essential ingredient in each of these claims. Is that sufficient?
The parties have to be the same under Article 27.
Well,
so
they may do, but I understand that. But leave that aside. You say that they have the same facts and the same juridical basis, do you? Because in each of them there is an essential ingredient that I have to prove that I'm the owner of the chattel.
Well, that would be an Article. As I say, that would be an Article 28 case if the parties were different. If the parties were the same, yes, yeah. Absolutely. If the position was that I had stolen your lordship's antique piano and you were suing to get it back, and then you subsequently discovered I'd also damaged it, so you were also suing me for the damage. If you brought one action in relation to that in England and the other action in France, then yes, Article 27 would kick in, because...
And what happens if you damaged it and then 5 years later you stole it? Well, still the same.
But if you were litigating against me in two different jurisdictions about the same issue, then obviously there's a risk of irreconcilable judgments if the two actions proceed separately.
And what is the juridical basis that's the same in both?
Well, the juridical basis on your lordship's hypothesis will be the ownership of a chattel, because that's what your lordship has hypothesised is the issue.
So any interference with ownership is the high level at which one in that case would identify the same juridical basis.
But your lordship's example illustrates both the narrowness and the importance of the doctrine. It's very narrow, because it's rather difficult to imagine a sensible factual scenario in which you would be litigating against the same person over the issue of ownership of the same chattel in two different jurisdictions. It's in practice it's very difficult to think of an example. But if you were, it would be just standing back, a very bad thing indeed if there was a risk of the two of them reaching opposite views. So in France they said you were the owner, and in England they said you weren't, because it would obviously be sensible for one to be stayed and the other to proceed. My Lord, my Lord, I'm now coming to the heart of my friend's criticisms of the judge's judgment, and he attacked he criticised the judge. The judge made two findings, and he criticised them. The second one first, and I'll do it in that order. And this takes us to the heart of the case, because the question is whether the juridical basis and the juridical basis of the claim, the rule of law, and the basic facts are the same. If one looks at the particulars of claim to start with, that's at in the core bundle. Core bundle tab 11. Well, while I'm on this point, I should have mentioned this at the outset, just in passing. Your Lordships will recall, I rose at the beginning of my friend's submissions because I was surprised by his submission that this was intended to be a global claim. The reason I was surprised, I just draw this to your Lordship's attention, is that when his solicitors were writing to my solicitors about the claim, this is in supplemental bundle. In the supplemental bundle, page 240. When they were writing about the jurisdiction challenge, as your Lordships have that, it's the 23rd of August 2019. On the second page of this letter, under identity of object, second paragraph, it is clear from the particulars of the claim in the English proceedings our client is seeking remedies for damage to his reputation in England and Wales only, arising from and caused by the publication of your client's tweets in this jurisdiction only. That point has been made more than once in correspondence, and if one looks at my friend's skeleton, just to complete this point, footnote 1 in my friend's skeleton, which is page 13, tab core bundle, tab 3, page 13. It says that it deals with the question of whether the Norwegian claim is global, and 5 lines down, in determining Wright's jurisdiction challenge, the Oslo District Court held it had global jurisdiction under Article 5.3, not limited to publication in Norway, such that there would be territorial overlap, so that the English action, if the same, would fall within the global claim in Norway. Court of Appeal is Wright's appeal to the Supreme Court. If that Norwegian appeal is successful, such a Norwegian court no longer has jurisdiction over a claim for English publication. It will apply to amend as English grounds of appeals. The cause of action cannot be the same if they indisputably concerned different publications in different jurisdictions. So as I read what's being said there is, his claim doesn't cover publication in Norway, as the letter indicates it covers only publication in England. It's as I understand the English rules of pleading, if you want to plead a claim covering damage outside the jurisdiction, you must do so specifically. And if you want an injunction seeking restriction of activity outside the jurisdiction, you must claim that specifically as well.
The principle of defamation pleading.
Yes,
it's a general rule of pleading.
Well, it certainly is a rule in defamation pleading. But my understanding of the rules is more general. If you in general, the presumption is the English courts act in relation to what's happening within their jurisdiction. If you want remedies which bite on people outside the jurisdiction, you must make it clear. But be that as it may, the particulars of claim, as the court's already seen, allege the readers would this is paragraph 4. That's reference, refer to the claimant. Paragraph 5, meaning, and paragraph 6, serious harm. So those are the elements of the claim that my friend, that Mr. Wright, Dr. Wright, seeks to establish in England. If one then looks at the opening writ in Norway, that's at in the English translation 12a. The first thing to note is, and I think this is a point my Lord Justice Popplwewell made very early on today. It constantly refers and repeatedly to the claims made by Mr. Wright. So if one looks at section 1, paragraph 1, Magnus Granath files suit against Craig Wright, claiming declaratory judgment and not liable to pay damages, claim that he's made libelous remarks and Wright has a claim for damages. Granath disputes these claims and asks for an exculpatory judgment in his favour. So he's saying Wright has made claims, and I want the I want the Norwegian court to say that those claims by Wright are not valid claims, and that runs through the whole of the opening writ. On a number of occasions, it says it refers to the claim for damages, and if one looks at ultimately the statement of claim at paragraph 4, perhaps what we would call the prayer, the court finds in favour of Magnus Granath in regard to the claim for damages raised by Craig Wright. So, what the Norwegian court is being asked to do is to provide an exculpatory judgment in respect of the claim for damages raised by Craig Wright. It's being asked to declare that those words are not libelous. That's at on page 100, the final paragraph. And that if they are libelous, he's not suffered any loss. There's no damage to reputation. Shouldn't be awarded any restitution for non-economic loss. The letter of claim is exhibited. The particular tweet on which the English proceedings are based is exhibited and referred to. The fact that other tweets are referred to is irrelevant. we say, what and the fact that it said in paragraph 3, Granath believes he can substantiate that Wright is not Nakamoto and that his allegations are therefore correct. That has to be read in the context of the claims that are being made and the tweet itself. As I said at the beginning of my submissions, the tweet itself says, forensics to CSW's first attempt to fraudulently prove his Satoshi. Now, what he's saying is that is correct. That is the idea that if he establishes that, if he establishes that it is correct what he says in the tweet, that would plainly, we say, be inconsistent with a verdict for, with a judgment for Dr. Wright in English proceedings for libel. Because if it's correct that he's fraudulently claiming to be Satoshi, he's not entitled to damages for libel. And what the Norwegian court, as I say, is being asked to do is to provide an exculpatory judgment. And this isn't, and my Lord, I'll make this point again in relation to the suggestion of abuse of EU law, but standing back, this is a Norwegian resident who's asking his domestic court to rule on his liability throughout the EU. It's a perfectly proper thing for him to want to do. Under the basic rules of jurisdiction, pre-Sheffield, if a global claim was going to be made against him, it would have had to be made in Norway, because it's the place of the defendant's residence. It's one of the places where Dr. Wright could have brought a claim. You can bring the claim in various places, but a global claim can be brought against Granath in Norway because he's a Norwegian resident. And so we say that if you look at the opening writ with just a little flexibility, if I can put it that way, not through the eyes of construing it as if it was an English pleading, but looking, what is it really about? What it's really about is saying, Wright's claim against me is a bad claim and I want to be exculpated. What is Wright's claim against me? It's the claim that's set out in the letter which is appended to the opening writ.
Well, Mr. Relansky would say, not so fast, Mr. Bond, because the claim as set out in the letter before claim was an English law claim, framed by reference to the ingredients of the English law of defamation. This document identifies in basis of claim what the exculpation is to be based on, which are elements not simply those identified in the English law framed letter of complaint, letter before action, if you like, but a different set of principles of Norwegian law.
Well, there are additional matters, of course. He's putting in his exculpation matters which in England would ultimately appear in a defence. But that doesn't make it any of the... It doesn't mean that the same ground is not being covered. We say it's plain that the same ground, the ground that's covered by the claim, which is you've defamed me and damaged my reputation. You've defamed me by saying I'm a fraudster and you've damaged my reputation. And in the Norwegian writ is saying, I'll prove that what I say is correct. You are a fraudster and your reputation hasn't been damaged.
Well, no, forgive me. What the pleading says at page 100 is that he believes he can substantiate that Wright is not Satoshi Nakamoto.
Well, that's one of the things it says.
No, at the heart of the Valenci's submission to us, right or wrong, but this is how he puts the case, is that there is in principle a distinction between making a statement which is incorrect and making that statement dishonest. And that's a distinction which is well known to English criminal lawyers, for example. Juries are often directed about that in an obtaining by deception case. So conceptually, that distinction appears to be, on the face of it, a potential point of distinction. And what he's saying is that if the pleading is accepted, even if the pleading is accepted in the Norwegian court, that would not necessarily be irreconcilable with an English court judgment in which the issue of dishonesty might be raised and have to be adjudicated.
Well, look, I know he says that, and with respect to him, it's fantastical. The position here is that the words of under the final paragraph of 3 can't, the final paragraph on page 100 can't be construed as if it's a statute. He's saying Granath believes he can substantiate Wright is not Nakamoto, that his allegations are therefore correct. His allegations aren't that he's not. His allegations aren't that he's not Sakamoto. His allegation is he's a fraud.
On its face, what the pleading says is, and therefore, in other words, for that reason, are correct. Now, it may be that the claim, that the allegation will fail. That's not any concern of this court or courts in this country. It may be that it's a bad point, and the Norwegian court will say it's a bad point. All that's being said is, for the appellant, that is the narrow scope of the issue which is raised on the facts of the Norwegian claim. And that's not the same cause of action.
Well, no, because you, as I say, you can't construe one sentence of this document in isolation. You can't construe it as if it's an English pleading or an English statute. What this document sets out to do is, as the introduction, as the first sentence makes clear, is claims a declaratory judgment that he's not liable to pay damages to Wright. Wright has claimed that Granath made libelous remarks on Twitter, and a claim for damages. Granath disputes those claims and asks for an exculpatory judgment in his favour. He's not asking for some narrow determination as to whether Wright is Sakamoto independently of Wright's state of mind. If one construes the whole document, and in the light of the material that's appended to it, I say a fair reading of it is he's asking the Norwegian court to say that what he said about Wright was right, that his statements were correct. He's not asking for some narrow determination, and the idea that Dr. Wright can be honestly mistaken about his claim to be the inventor of Bitcoin is extraordinary. I mean, either he did or he didn't do it. But we say that if you look at this document as a whole, not just picking out the sentence that your lordship has picked out, that what it's asking is, this is the claim brought by Wright, and I want, for these reasons, I want the Norwegian court to say, to find in my favour in regard to the claim for damages raised by Craig Wright. He doesn't say that he wants the court to find in his favour in regard to part of the claim or one aspect of the claim. Now, the fact that this doesn't plead a meaning in the way that an English lawyer would expect in a libel case, or to see in a libel case, is exactly the kind of point I was talking about earlier. One can't expect a Norwegian opening document to behave as if it's an English document. What one has to do is look at it in broad terms, and here the basic facts, the juridical basis of the claim, the rule of law, is personality rights, defamation, the damage to reputation, And the basic facts are, Wright has said these things, Granath has said these things about Wright, and Granath wants the Norwegian court to say he hasn't libelled Wright. And when one puts those things together, there's only one possible conclusion. If the Norwegian court finds in his favour, that will be inconsistent with an English judgment in favour of Dr. Wright. We say there's no, as a matter of reality, there's absolutely no space between the two. And the fantastical hypothetical suggestion that perhaps the Norwegian court could find that Dr. Wright was honestly mistaken as to whether he'd discovered, he'd invented Bitcoin or whatever, it doesn't assist at all. The reality of the position is that if judgment is given on this claim, on which the Norwegian courts have taken jurisdiction, and as a global claim, so covering damage throughout the EU, that there'll be, on one view, there will be incompatible judgment. Well, those are my submissions on that. So we say that the turning to the judgment of I'm conscious of the time. The turning to the judgment of Mr. Justice J. He's when he perhaps he could have expressed it in a slightly clearer way, but when he's talking about his hypothetical and the issues raised, he's the first basis on which he finds what he's saying is, look, here in assuming there's no issue about meaning, and he doesn't deal with harm, which is clearly an issue in both proceedings, but which he should have dealt with, we would say. But what he's saying in his first finding is, if Mr. Granath is right and establishes the things he sets out to establish in Norway for his exculpatory judgment, then there would be what would then happen would be a clear possibility of a irreconcilable judgment with an English libel judgment in favour of the claimant.
Can you, Mr. Tomlinson, the first way the judge put it, paragraph 62 to 72, which is the hypothetical way. At paragraph 69, the judge said, requires some examination of the core issues in both sets of proceedings. So he looks at the claims.
Yes.
He expressly directs himself that one doesn't look at the defences, and you've made that point. But he concludes 69 by saying, the comparison must be limited to the issues raised in Norway, truth, public interest, no loss. Those raised in England, innuendo, meaning. And he poses this important question, is the absence of intersection or overlap critical? Well, I have to say, speaking for myself, I find it surprising that the judge concludes in a case where there is no intersection or overlap between the issues he himself identifies, for him then to conclude that in fact they amount to the same cause of action.
But I make 2 points in response, my Lord. The first is he's entitled to look at matters in the Norwegian proceedings which would be defences if they were pleaded in England, but in Norway have been pleaded as positive cases. And those are the issues that he identifies at 69.
Yes.
Strictly speaking, if those were the only issues, truth, public and public interest don't arise on the English claim. However, if one stands back and looks at the basic facts are that that Dr. Wright is seeking to establish that he has been defamed by this tweet. If it's true, or if there's a public interest, he hasn't been defamed by this tweet. So in that sense, there's a commonality, because, and that's the point that the judge is seeking to get at as we read him at paragraph 70. He's saying, if you look at, on this view, on this hypothesis, you look formally at the issues, yes, there's no overlap. But if you stand back and look at the basic, what's going on in this case, then there's the risk of irreconcilable judgments. That's in substance what he's saying, and not he's right. I mean, if the Norwegian court found that what was said was true, and its publication was in the public interest, then no Norwegian court is going to enforce an English judgment for libel, because they found it's true. Well, I think that's the point he's getting at. I say it's not. It perhaps could have been more clearly expressed.
No, thank you.
And in relation, I know, my Lord Justice Singh raised the point with Mr. Wolanski, but in relation to meaning, this is the second basis.
Yes.
What Lord Justice Popplwewell, the 2 points. First of all, one has to look at issues and not disputes. So one has to look at what's in issue in each set of proceedings, not what's in dispute. We don't actually know what's in dispute because we haven't got defences. That's in either of them. So, but we know what's in issue by reading carefully the pleadings. Now, in the English pleadings, we're familiar with that, and we know that meaning and serious harm is put in issue. In Norway, we're not familiar with the pleadings, but we know that what is put in issue is correctness, and we know what is put in issue is serious harm, is damage. It must logically follow that if correctness is an issue, meaning must be an issue. And so, although the judge says, maybe not in dispute, but in issue, and although the judge says, again, expresses himself perhaps slightly, unfortunately, in paragraph 74 and 75, we say what he's really saying is obviously correct, namely that looking at if someone is going to establish this claim in Norway, one of the steps along the way is the determination of the meaning of the words used. And that's one of the steps in England. And so, whether in dispute or not, as the phrase that he mentions from the Primacon case, whether it's in dispute or not, those are issues in both cases, and so there is a commonality.
And you would submit that whether the meaning is defamatory is intrinsically part of the Norwegian claim as well, because
yes,
you'd only be considering the question of truth and whether it's not libelous. If otherwise, yes, it would be libelous.
Yes, if it's said that it means that Dr. Wright is a decent chap, then of course there's no question of defamatory, and so there's no question of truth arises at all.
Well, I see that, but I think that what is said against you is that the test which the judge posed for himself at paragraph 77 and 78, which is the first of the two logically possible approaches he identified, and he said it was the correct one, that he got that. That's a novel test. It's not the test in the authorities.
Well, it's another way of we would say of formulating the approach taken by this court in the Easy Group case. You look at it, an essential element. An essential element in both cases is meaning and serious harm to reputation. So
I'm having difficulty with this, I'm afraid. I mean, you may be right, but I'm having difficulty reconciling that proposition with what is said in the major authorities. For example, the Alexandros T case, which we were shown by both sides, that it is not sufficient, that there is that there will be common issues. There's not an issue case; it's a cause of action, which has to be the same.
Yes, it is. It is a cause of action. But as I said by reference, I hope I've established by cases such as Prima Common Easy Group, that everything doesn't have to be the same. It's sufficient that there is an essential element, that the rule of law and the facts have enough in common to give rise to the possibility of irreconcilable judgments. So that's what it's about. And here, as I forgive me, I've made the point already, but here the possibility of irreconcilable judgments is absolutely clear, because what Mr. Granath is seeking is a judgment to say that he's not done the thing which Dr. Wright accuses him of doing, namely defaming him. Well, I'm very conscious of the time, and I've got the second issue to deal with. So perhaps I just need to say something about the same object. The case that my friend referred the court to this afternoon, it isn't a authority for the proposition that if there are different remedies, then the object isn't the same. It's a case actually like the Alexandros T, where why Article 27 doesn't apply is because in one case the claim is about enforcing an exclusive jurisdiction clause, and in the other case it's about a claim for damages. And it's not, you could, whether or not there's an exclusive jurisdiction clause doesn't bite on whether you succeed in a claim for damages. It may bite on whether the court trying the claim for damages had jurisdiction, but it's not the same. It's obviously not the same object. The classic place, which my friend didn't refer you to, but the classic place where this distinction is drawn is in the Gubish case, where perhaps I just give the court the reference because of the time. But at paragraph 17, it said the two actions have the in those circumstances it must be held the two actions have the same subject matter. That's another synonym for the same object. Paragraph 17. That concept cannot be restricted as to mean two claims which are entirely identical. And there's never been any claim there should be identity of remedy. The remedies, for example, in Easy Group, well, in most of these cases, you very often get in one jurisdiction a claim for damages and the other a claim for declaratory relief. But the two claims in the Easy Group case were completely different. But I ought to go on to ground two. My lords, dealing with this as briefly as I can, if there's a Mosaic claim for damages, the claim in each jurisdiction is the same cause of action but has a different object. That's the effect of the decision of the Court of Justice in the Mertz case. Mertz was about trademarks and about what would happen if, well, in that case there was EU-wide actions for the enforcement of EU trademarks and an action in the UK for enforcement of a UK trademark. And the question was, in that case, whether the equivalent in the trademarks regulation of Article 27 gave rise to a finding of lis pendens. And my Lord, if I can just refer you to very briefly to the relevant passages. It's at tab 13 of the authorities bundle. And just taking it up at 37, paragraph 37. Successive civil actions on the basis of EU trademarks and national trademarks must be considered for the purposes of application of 109, which is the equivalent to Article 27, as having the same basis. They're based on the exclusive rights arising from identical trademarks. If the action brought before the court first sees is based on a national trademark, the action before the court, other than the court first sees on EU trademark, in such circumstances inherent in the rule of lis pendens laid down in Article 109 regulation, trademarks regulation. As regards cause of action, it's clear the order for the reference, the actions initiated for the High Court of Justice and the Hamburg Court concern the use of the term merc on the internet and domain names, so on. Therefore, it's apparent that subject to verification by the referring court, the condition relating to the identical nature of the facts, like that relating to the identical nature of the cause of action, is satisfied in the present case. So the causes of action are the same. However, as regards subject matter, that's object, as it's sometimes put, this means that the end the action has in view, the concept subject matter cannot restrict it to mean two claims are formally identical. Account must be taken of the applicant's respective claims, each set of proceedings. And they go on at 42 to say the actions initiated by the court in the previous paragraph must, for the application of that provision, found to have the same subject matter only insofar as the alleged infringements relate to the same territory. So in other words, although there's the same cause of action, lis pendens doesn't apply because they have a different subject matter. So if in this case, if Dr. Wright had brought 27 separate actions, then the doctrine, Article 27, wouldn't have applied.
Provided they were Mosaic actions.
So, well, in this case, yes, I'm so sorry. 27 separate actions for the damage in each member state. So Article 27 wouldn't have applied. However, that's not the case if a global claim is brought. And it's plain, I think Mr. Wolanski was prepared to concede this, although perhaps I'm wrong about this. Perhaps in the end he wasn't prepared to concede it. But it's not possible to bring two global actions at the same time. If Dr. Wright had brought a global action in England and a global action in Norway over the same tweet, it's perfectly plain that Article 27 would apply. One of them would have to be stayed, because it would be the object, the cause of action would be the same, and the object, because he'd be claiming for exactly the same damage in two separate actions. So there are no. These aren't special principles that apply to personality rights actions. They apply to any action where the place of commission and the place of damage is different. The leading case is actually about pollution, and where the polluters release the polluting material into the Rhine in France, and the damage then happens in Belgium. But if there'd been one person that suffered damage from the pollution in Belgium and the same person suffered damage in Holland, there'd then be the equivalent of a Mosaic action could have been brought in Belgium and Holland. There's no magic about personality rights actions. It just happens. It's rather easier to separate damage in each jurisdiction in such an action and have the same parties as it is in a nuisance action or any other kind of tort. But the so-called hypotheticals that my friend puts forward don't help him at all. The first one that he advances is where I think this is it's slightly different in his oral submissions and his written submissions. But if, as in this case, a negative declaration action is made in relation to a global claim, then Dr. Wright can counterclaim in Norway for global damages. The suggestion he can't get an injunction in Norway is misconceived. It's misconceived for this reason, that as he says, he has a right to an effective remedy under the EU Charter and the EU Charter of Rights. That right must apply in Norway, which is subject to the Charter, as much as it does in England. The Bollung supply case proceeds on the assumption that you can get an order for removal of material from the internet in whichever jurisdiction you can properly sue for global damages. It says you can't get such an order on a Mosaic basis, but if you're suing for global damages, you can get an order to remove the material from the internet. It proceeds on the assumption that that can be done wherever you can sue for global damages. And the idea that somehow there are some European jurisdictions that in breach of your rights under the Charter deprive you of effective remedies is a remarkable one, which is not backed by any evidence or any authority. It's obvious you can get an effective remedy. You must be able to get an effective remedy in accordance with your European rights wherever you sue. So Dr. Wright is not in any way disadvantaged by suing, by having to counterclaim in Norway in terms of the remedies that are properly available to it. The suggestion that somehow what Mr. Granath is doing is an abuse of EU law is a surprising one. What he's doing is exercising a right which he's perfectly entitled to do in the Norwegian courts. The Norwegian courts have accepted jurisdiction for him to do this. Dr. Wright has unsuccessfully appealed that decision twice. Mr. Granath is exercising a right which he's entitled to exercise. He's not abusing EU law in any way. And here, there is no substantive. The position is there's a global claim for damages in Norway. There may or may not be a global claim for damages in England. But the position is that Dr. Wright is not being deprived in any way of the opportunity to seek damages in whichever EU jurisdiction he wishes to seek them.
Does the EU Charter apply in Norway?
Well, forgive me for not knowing the answer directly. My recollection is it does, because the EFTA Norway's an EFTA country, as you will know. My recollection is that the EFTA countries are bound by it. But well, I can check that and let the court know if that would be helpful.
Well, it's rather central to your submission.
Yeah,
Because an injunction would be available in Norway.
well, my understanding is that it is, but I apologise for not having chapter and verse.
But we don't have any evidence about things were said to us.
Yes.
We haven't looked at the unagreed evidence, the unagreed bundle. I mean, what the Norwegian courts would do, I'm afraid I just don't know. So that's why I thought it was an ingredient of your argument just a moment ago, that they will have a right to an effective remedy under the EU Charter of
Yes,
Rights.
well, it is my understanding the EU Charter applies in Norway. In any event, Norway is a party to the European Convention on Human Rights, and again under that, obviously there's a positive obligation under Article 8 to protect.
Well, that may be so, but with respect, you said a moment ago, at the end of the day, it may not matter, but you did make the submission that Mr. Wright would be able, in the counterclaim in Norway, to claim an injunction.
Well, I don't think there's any doubt that he would be able to claim an injunction in Norway. Whether he would obtain an injunction in Norway is a matter that may be subject to dispute. But and I apologise for not having chapters, I say, for not having the chapter and verse on this. But my understanding is that the charter is also binding in Norway, but I can confirm that or otherwise to the court. But as I say, the Bolag supply case, which as the court knows, lays down the rules about where you can and cannot obtain injunctive relief in personality rights cases, proceeds on the assumption that you will be able to obtain that relief in any country in which you can, any jurisdiction in which you can bring a global claim, because otherwise it would be the remedy would be ineffective, because if it wasn't available in principle everywhere, in some cases people would be being sent off to a place where they couldn't get the very remedy they needed. But my lords, in this case, in any event, none of this matters, because the position is here. All these questions about whether or not if Article 27 applies, then there should be some Cheval in some way should trump the application of Article 27. All of this is irrelevant for the reason the judge indicated, because here you've got a global claim, and a global claim in Norway, and the position is that the global claim can be, a global counterclaim for damages can be brought. So Dr. Wright is not deprived of, he can still claim for damage in any jurisdiction he wants to claim for damages, or all jurisdictions or only some of them. I say it's not really clear where he's claiming for damages. And Lords, I'm very conscious of the time, and I think unless, is there anything else that I can assist you?
No, thank you very much indeed. Yes, Mr. Lansky.
Well, just one very short point, factual point in reply. My understanding is that Norway is not signatory to the Charter, not subject to the Charter, because it's not in the EU. And that if Norwegian law doesn't provide a remedy, then the European Court can't give those courts that power. So it's not a signatory to the Charter.
Well, as there appears to be a dispute, Julie, perhaps you could just resolve that and send an email to the court.
We can.
You'll be able quite easily to establish
We will.
whether that's accurate or not.
But my Lord, I have no further permissions to make a response.
Thank you. Mr. Molansky, Mr. Tomlinson, thank you both very much for your respective submissions, and thank you to you and your teams. We're going to reserve our judgment. It will be handed down in the usual way, which will now either be remotely or in person, but in either event, nobody need attend, and we would hope in due course you'll be able to agree an order, and if there are any issues outstanding in respect of that, then they'll be dealt with on the papers with, if necessary, very short written submissions. So thank you very much.
Rise.